Well, first of all, I'll mention that I'm speaking in my personal capacity today, a bit about some of the broader issues and possibilities for developing countries in the current international tax environment. We have many excellent speakers after me, many of whom I know, and I should say I'm not from a developing country, but I've worked with them a lot. And the UN Tax Committee and the UN Secretariat work is mandated to give special attention to developing countries. So hopefully I can bring ideas. It will be helpful to you as we go forward. I've really enjoyed this conference. I've enjoyed the discussion on wealth taxes. I look forward to the discussion on green taxes and so many other discussions. I think it's really done very well. So thank you for persevering. So what countries are we talking about when we talk about developing countries? As we all know, developing countries are not monolithic. There's so many differences: size of economy, level of development, history, including colonial history, history with business, natural resources, education levels, climate, relative size, importance of the public sector and the private sector, their production, their exports, and also their perspectives of governments and citizenry, including on tax, trade, and investment issues. So there's a whole range of opportunities, and one of the best things we in the UN can help developing countries do is realise the commonalities with other developing countries, and even sometimes with developed countries, and work together to get a result that's good for all. There are certain natural groupings and commonalities. They tend to be capital importers. They tend to have a preference for where either source or residence taxation has to yield to avoid double taxation. In those cases, they tend to say we should be able to preserve our source country taxation rights. At the moment, they're very keen to get simplified approaches, resources, and also limited information. They're often at a very asynchronous position as regards multinational enterprises, for example, about what the key, often very high-level information. They tend to have a preference for withholding taxes, often final withholding taxes, and the UN has been a bastion for the importance of withholding taxes. They're not perfect, and they need to be set at a reasonable level, but they're a very important way of making sure that some tax is received, and it's received in good time, not having to wait until the end of the year, for example. Developing countries often have limited bargaining positions in their double tax agreements, for example. And I'll talk about some of aspects of that later. Corporate income tax, and I'm talking mainly about corporate income tax, just to keep this within a reasonable scope, not because other taxes aren't very important. Corporate income tax is often more important proportionately for a lot of our developing country members, and often it relates to a very small number of multinational enterprises. Another thing people often forget, and I think it's important in the current context, is what we call tax morale issues. Often developing countries are building tax systems, building credibility of the tax system. And there's often the issue, will natural persons pay taxes when legal persons don't appear to be paying taxes? That's an issue which is very important and often forgotten. And some countries, of course, have a foot in both camps. They're both capital exporters and capital importers, and emerging economies often fall into that category. Sometimes they have commonalities with many other developing countries. Sometimes they might look at things from a slightly different perspective. So who are the stakeholders that we deal with? We deal with governments, we deal with business, we deal with personal taxpayers who have an interest in the amount that they pay and that others pay. And of course, we deal a lot with NGOs and with academics. But one stakeholder that I think is very important, we see everything through the light of sustainable development, the importance of tax for sustainable development. Official development assistance, aid, is important for development, but the longest term, the best approach is a good tax system that works for sustainable development. And this is the last stakeholder that is often forgotten. And that's the citizens who are legitimately below the tax threshold. And they're the beneficiaries. They should be the beneficiaries of sustainable development that the domestic resource mobilisation, the good tax system can bring. They're very important to us, even if they're not taxpayers in a one common definition. So what exactly are we talking about? Well, we're talking at the moment about the future of international corporate income taxation. So it's very important that developing countries have an important role in that discussion, and the results yielded work for developing countries. And I think the essence is that how do we draw upon the past and draw upon present situations to build a workable future that stands the test of time? It's not an easy call. But often looking to the past can be quite instructive. So one of the big issues at the moment for developing countries is that when you're looking at the international allocation of taxing rights, remember that we're talking about, to avoid double taxation, which country is going to yield its taxing rights. When we're talking about that international allocation or reallocation, a lot of focus has been entirely on the supply side. The idea that the place of taxation is where companies produce things for sale, wherever they're actually sold. There was probably a subtle meaning of that in the term of value creation. Certainly a lot of countries, when they use that term, were basically talking about the things that companies do, and they didn't talk about the importance of the market to value creation or value capture, which is another way of looking at it. But others, and this is increasingly important for developing countries, think that there's too much emphasis historically on the supply side, on the idea that the value really comes from where stuff is made and not from where stuff is sold. And they look more to the interaction of demand and supply. And this is one of the trends at the moment, which developing countries should pay attention to in the negotiations, not just in the OECD inclusive framework, but in UN negotiations, for example. And the justification for looking more at the demand side is that the business profits of the foreign enterprise derive partly from the enterprise's use of locational advantages in the developing country, often very strong locational advantages with growing markets and growing middle classes. And that's what makes a lot of the company's business operations profitable and even super profitable. That includes the means of transportation, internet availability, public safety, an educated public, an emerging middle class, a legal system that ensures the protection of intellectual property, and a financial infrastructure. And of course, those sorts of things will vary across countries, but some people see that as an important justification for taxation at the level of the market, where others say you don't even need that. The mere fact that there's economic engagement in the country and value capture from the market should be sufficient. You needn't link it to any particular locational advantages. One thing I think is important to bear in mind is that all these approaches are okay in domestic law. They're all valid in domestic law. Virtually any approach to taxation profits which are made through a connection to your market have validity, I believe, in international economic law. And there might again be a subtle attempt in some areas at the moment to develop a customary international law of international taxation, which suggests that generally the market should not be the country of the market should not be the place of taxation on profits derived from that market. And I see a subtle movement towards that. I don't believe that's the case, because as a public international lawyer, to have public international law of any sort, you need to have not just practice, but countries have to practice it in the belief that this is actually customary international law, not because it's just part of a package deal, for example. It's called opinio juris. So there's a separate panel on multilateralism, and I just want to make a few quick points because that's a very good panel coming up tomorrow. And that's that multilateralism is not a hermit. Multilateralism plays frequently and it plays well with others. So often we hear of multilateralism as though it's the polar opposite of unilateral actions, but I don't think that's the case. The the multilateral approaches, which we believe very strongly in the UN, can affect, for example, the OECD minimum standards. They can also affect, for example, how countries are addressing their tax legislation to deal with COVID-19. There is a lot of multilateral looking at what's happening and discussing what's happening. And another good example is domestic transfer pricing legislation. The multilateral influence of guidance from the OECD, the UN and others is sort of helps coalesce domestic law without supplanting the essential aspect that it's domestic law. And multilateral measures often reflect unilateral approaches, often from the larger economies. Pillar 2 of the OECD Inclusive Framework project heavily reflects the US GILTI, for example, even though it may end up grandfathering it. So there is a complex interplay between these different levels. And also bilateral approaches often show the influence of multilateralism. You look at the UN Model Tax Convention, Article 12A on fees for technical services. That helps coalesce the pros and cons of taxing fees for technical services, the arguments for and against, the possible language is systematized. So it plays a role in ensuring that if you want to do the same thing, you do it in the same way without telling countries what they want to do in their treaties. And it also, in fact, drew very widely upon the bilateral practice of developing countries to get an article that reflected that. That may happen too if there is an agreement by the committee next week or the week after to have an Article 12B on digital, which is on our website. If you look up UN Tax Committee, there is a discussion on that. But also, even those sorts of things can help confirm that underlying domestic measures preserved in the treaty are okay, they are legitimate. I think this is an aspect that people often say the UN work, because you have to negotiate your treaty, the UN Model Tax Convention is a very long-term project, but not necessarily, because even in the immediate sense, it can signal the legitimacy of domestic law taxation based on introduction into the market of technical services with no need for a permanent establishment. So that's an area where different countries will take different views on that, but at least it gives a respectable approach on that. And that signal is an immediate signal. So everything is not long-term, even though the treaties might take long-term. Multilateralism has also informed a lot of the good work in Africa on taxing offshore indirect transfers and the recent ATAF work on digital services taxes. Obviously, developing countries need to also consider the trade law and investment law aspects of their tax legislation and their approach to taxation internationally. That's a big subject, so I won't deal in any detail. But what this means is that small that developing countries, including small and least developed countries, need to be part of the DNA and the leadership and the interpretive mechanisms of the institutions like the UN, which are trying to reflect the currency of international thinking and make sure that tax laws globally are up to date with the world as it is today. Just a few points on what makes for a good agreement for developing countries, just talking generally, and I'm not focusing on particular current processes. It does apply as much to the UN and other forums as it does, for example, to the OECD and the Inclusive Framework. We do always need to assess, is there a minimum level of commonality that can yield a good multilateral result? The fact that some countries are willing to accept some taxation at market level doesn't mean that there's enough commonality about how much taxation at market level is appropriate. Use of language. I don't use the term a new taxing right in the context of taxation by the market or user state because it's not a new taxing right. It's allowable in domestic law. And what it's really, if anything, is it's a reallocation, which may vary between the UN and OECD models. It's a reallocation of taxing rights in cases where under treaty, you say, to avoid double taxation, one side or other side must to some extent yield to ensure that we don't get double taxation. So it's really, if anything, it's a change of the normal rules of allocation of taxing rights rather than a new taxing right, in my view. So there are issues at the moment about complexity. Developing countries tend to prefer less complexity. Of course, with good drafting or bad, complexity can help deal with abuses, or it can give the opportunity for abuses. And actually, you can say the same of approaches which are oversimplified. But a lot of developing countries believe that the costs of complexity fall too much on the developing countries. One of the issues we have at the moment is that we're building an effort to deal with taxation of the digitalised economy. And one of the challenges of the multilateral framework is it's fairly slow. It'll be some years before multilateral treaties are enforced at the domestic level and money is coming into the revenue. So is there a way of ensuring that in the meantime there's some melding of a multilateral approach to bilateral tax developments to unilateral tax developments to make sure they're essentially multilateral, but maybe a little bit quicker than traditional conventions? There are a lot of things that make a good agreement for developing countries, and I will leave you some slides, but one of the most important ones in the area of digital taxation is if we're responding to the old rules saying they're outdated by business changing the way it operates in a digitalised world, how do you know that a multilateral approach is not going to itself be outdated by the way business is done in a few more years? And that's quite an issue. How do you have a multilateral approach which can then be multilaterally amended as necessary without creating too much uncertainty for governments and for taxpayers, and in a way that is reflective of developing countries as well as developing countries? One of the other aspects which I think is really important for developing countries is just to get capacity development on negotiation of multilateral agreements generally, including, and this applies to a lot of countries, developed and developing, how do you negotiate from a position of apparent weakness? There's a whole range of discussions on how you can negotiate from a position of apparent weakness. And there's usually levers that you can pull to make sure you get the best possible result. And I would urge developing countries not just to get negotiation on bilateral tax treaties, but also on how you negotiate from your best multilateral negotiators in a multilateral environment. My last point is, of course, we're in an era because of COVID of not only needing to respond and have money in quickly from businesses that are earning money, also to recognise that some businesses are not profitable at the moment. How do you deal with those issues while taking a multilateral approach which may take some time? And that, I think, is one of the great tensions at the moment. And the issue is, can you do some melding of longer and shorter term measures or interim measures which are conservative but will yield something while you await the multilateral approach? Remembering, if you have nothing in place and you have a multilateral approach only, there is an incentive in some players to actually delay the multilateral negotiations because there'll be no taxation in the meantime. Finally, virtual negotiations and tax. We have to get used to virtual negotiations with the good and the bad, including the internet downages that we've seen, but also the great possibilities which we've seen in a conference like this. The reach is really great through the use of the internet. We've had capacity building for a lot of people who just could not possibly come to New York for capacity development. But there's less opportunity to build networks, especially for new players. There's time zone issues for a lot of you. Often Asia bears the brunt of these. And the ability to participate is internet quality dependent. It's also very hard to draft through an internet meeting. So developing countries will have to think about how we can use the upsides, including the vast reach and the ability to participate without travelling, to negotiate more generally while dealing with the downsides. I did have one slide, and I'll tell you what it said. It was the big banner from the Addis Financing for Development conference, which said, if you're not at the table, you're on the menu. And I had that slide up because I wanted to point out that's fairly well recognized now. But my final point is that you would recognize this if you're from a developing country. It's not enough to say that, because what you have to recognize is you need to be able to choose the appropriate menu, to play a part in the choice of menu, which is appropriate to the participants. You need to be able to choose the ingredients, and you need to be involved in the cooking as well. So I think great when people are at the table, but they need to be behind the menu and behind the cooking, and then it will be something that works for the greater number of countries for the greatest amount of time. Thank you very much for that.